felon's not engaged in his employment, or maturing his felonious little plans.
All right, so I'm Matthew Harget from the Spokane County Spokane County Public Defender's Office. I'm the Deputy Director. The CLE today is on conflicts. We're going to be specifically dealing with not only conflicts of interest, but also some work-related conflicts, because those are things that we see in our day-to-day jobs. I'm going to start off with, you have a right under the Constitution to conflict-free counsel. And the authorities that we're usually looking at are the rules of professional conduct, statutes, case law, and for us as county employees, we also look to county policy. Resources, when you're looking up conflicts of interest stuff, you might want to check with a supervising attorney. You can also check with the Bar Ethics Hotline. The rules of professional conduct are available online with the comments. A lot of people will also call Professor Strait, who's an expert over in the Seattle area. But you know, go to any supervising attorney and just bounce your issues off. The RPCs that affect us most commonly are 1.7 through 110, 116, and then a couple 37 through 8 that are special for lawyers and prosecutors. And then 8.4 is just kind of a general catch-all misconduct that someone might commit. Could be a crime violation or violating court or something like that. The first one is the RPC 1.7, talks about conflict for current clients. Basically, the test is if the representation of one client would be directly adverse to another client, or if the representation would be materially limited. What I get a lot of times is someone will come into my office and say, hey, I got this case where all these people know each other. Is there a conflict? And I can't really tell. The test is going to be whether or not the representationist would be adverse. So the easiest one to look at is when you have a couple of clients who are pointing fingers at each other, and what's your comments on the rules of professional conduct, or that, you know, it's all about loyalty. Loyalty is mentioned about 50 times in the comments for the RPCs. And it's loyalty and independent judgment are essential elements to a lawyer's relationship to a client. Concurrent conflict can arise from the lawyer's responsibility to another client, a former client, or a third person for the lawyer's own interest. So if you're looking at the conflicts, those are usually ones that the case screeners will catch right off the bat, because they'll see the co-defendant's names in the caption. And you have two clients who are pointing fingers at each other saying he did it. That's an easy one, and that's easy. When we're trying to figure out which client to farm out, usually we look at which client came in first, which client has a more serious case, who's in custody, things like that. The reason the interests are adverse with co-defendants is each defendant may seek a better plea bargain by throwing the other one under the bus. Each could be a witness against the other. And cross-examination would be pretty impossible for a single attorney who would have to impeach one, maybe undermine the other. So are there any situations that you can think of where you have co-defendants where it's not a conflict?
Sometimes people who are couples will not point the finger at each other.
Yeah, definitely if they're best buddies and they have a mutual defense. Usually alibi is a really good example to co-defendants. Their defense is, we were in Coachella that weekend, you know, we've got tickets, we've got hotel reservations, and there's pictures of us. There's really nothing inconsistent about that. As a practice, usually in our office, we'll go ahead and conflict those out right away anyway, just because the potential's there. You don't know what's going to happen later. Maybe one of the clients, you know, when it gets close, the prosecutor will start offering a deal for one to testify against the other, and then it would be impossible for one firm or one attorney to represent both of them at that point. So an attorney is duty-bound to withdraw when a conflict of interest arises. The trial court abuses its discretion when it refuses to allow withdrawal based on a demonstrated conflict of interest. And this could come up with, you could be in the middle of a trial when you realize that there's a conflict or something, an issue just came up. If you demonstrate that to the court's not going to be happy about it, but they're going to be required, you know, and there may even be a mistrial because of it, but they're going to have to allow the case to be conflicted out. Conflicts can also arise when the victims are witnesses or clients, and that happens obviously, you know, the clientele we have, you know, one week somebody might be a victim of the DV, and then a few months later they're charged as the defendant. So it's obvious adverse if they are testifying against your client, if they're current clients. But even if it's a friendly witness, we would probably want to conflict it out just to avoid the occurrence of conflict. Rule 1.8 talks about specific types of conflicts for current, and mostly This mostly applies to private attorneys who are doing business transactions, banking, real estate, and even some family law stuff. But there are exceptions for when there's conflict. You can get, if it's a fair and reasonable situation and fully disclosed, or there's no interference with the lawyer's professional judgment. Since we don't handle our clients' money, we don't usually run into this, and I always advise public defenders should never handle their clients' money. This is the one that kind of comes up a lot, Rule 1.9. This deals with former clients, and this is the one probably we get the most disagreement between attorneys about whether it's a conflict or not, or whether it has to be sent out. So what the rule says is a lawyer who has formally represented a client in a matter, or whose present or former firm has formally represented a client in a matter, shall not thereafter use information relating to the representation to the disadvantage of the former client except as these rules would permit, or require with respect to a client, or when the information has become generally known, or reveal information relating to the representation except as these rules would permit or require with respect to a client. So the question we get a lot of times is, I got a case, and this case I represented the victim several months ago on a different case. Is it a conflict? And the question, the answer is going to be, kind of depends. So here's our first hypothetical. Attorneys Archie and Betty work in the same public defender office. Archie represented Carla 2 years ago on a theft charge. The matter was resolved by plea. Betty gets a new file for Doug, who is charged with assaulting Carla. Doug claims Carla is lying. Can Betty continue representing Doug? Any thoughts? Well, Summer? I saw you raise your hand. Okay. You might need some more information. You might want to know, did Betty ever work on Carla's case or discuss the case with Archie? Does the office have effective means of screening their cases? Some law firms, it's kind of assumed that everyone in the law firm is going to be in on the confidential information. Private firm where I worked, once a week we'd have a meeting where everybody would discuss their case. And in that case, there's really no screening between lawyers on their cases. Is there information that Betty would use against Carla generally available? Could you get it from another source? So let's say, these are examples where Betty would definitely be excluded and disqualified. If Betty had covered Carla's plea hearing originally, maybe Archie was out sick that day. If Betty helped Archie with a suppression motion, read Carla's file. If Betty specifically remembers discussing Carla's case with Archie, maybe she even recommended that Carla take a plea bargain. Any of those situations, she's going to have confidential information about Carla's case and should not represent Doug. But another hypothetical, let's say Alice, the public defender representing Barry 12 years ago on a misdemeanor assault, and then Barry pled guilty, completed probation, paid all his fines. A few years later, Barry gets a theft conviction, but he's represented by another attorney in the firm. Alice is now representing Cynthia on a DUI, and Barry is listed as a witness who saw Cynthia driving. With regard to Barry's theft case, Alice never received any type of confidential information. Her office has effective screening practices to prevent unauthorized access to client files. Can Alice use certified copies obtained from the clerk's office of Barry's theft conviction to impeach his testimony? Zach, what's your thought?
Yes, because that information is in the court file and readily available.
Yep. And you know, some of these there may be disagreements, and we don't all have to agree because it's law. You know, people are going to have just different opinions. But the rules do say that the fact that the lawyer wants or declined doesn't preclude the lawyer from using generally known information. And also there's language about, you know, the personally disqualified attorney is screened. So the suggestion would be, if you're going to keep the case, don't talk to the other attorney who represented the former client on the theft conviction. And it feels weird, but it's RP 1.16, declining or terminating representation. These are really specific rules. There are mandatory withdrawal if the representation will result in violation of the RPCs or other law. Permissive withdrawal if the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent, or the client has used lawyer services to commit a crime or a fraud. Either way, the withdrawal has to apply with applicable law requiring notice and permission of the tribunal. And what will happen here is sometimes you'll have a client who there are jailhouse lawyers who have theories about practices, and then they'll go around the jail, and then a whole bunch of people will come up to you with, you'll see the same issue come up over and over again. So let's say your client tells you he's planning to commit perjury if he testifies. What should you do? Jeff had this issue.
Yeah.
What'd you do?
Told him, you're not to do that, and I can't help you. Then he persisted, saying he's going to do it. At that point, I had to get off the case.
Exactly right. So the lawyer's not obligated to withdraw immediately just when the client makes a suggestion that they might want to do anything. But the lawyer has to be mindful of their obligations under 1.6 confidentiality and 3 candor to the tribunal. So it kind of puts you in a sticky position if you have to do a motion.
So best practice is to warn the client that if they do that, or if they persist, that we'll have to withdraw.
Best practice is try to talk your client out of it, first of all. Any crime that they want to commit, try and talk them out of it. And then explain to the client, what the rules are, saying, hey, look, I don't want to do anything to hurt you, but we're going to have to go, the only way I can get off this case is we're going to have to go in front of a judge, and the judge is going to ask why. And I'm required to be honest and tell the judge why I'm getting off the case. I can try and give as little information as possible. I can say it's because Rule .116, it's a professional situation, I have to get off. But that pretty much signals to the prosecutor and the judge what's going on. They're going to be able to read the code and know what's jeopardy.
I think, though, this is a little gray area. I think in Compton's situation, the client specifically told him he was going to lie on the stand. But we also have other clients, I'll use one of my clients as an example, that right before in a trial, I heard a little different story each and every time. It changed a little bit. But frankly, I don't, the people give us a lot of bullshit, and I don't know what bullshit is true or not true or whatnot. So I wouldn't have thought about reporting him with this story because I didn't know for sure. But in Compton's case, it's different because the client said, I'm going to get on the stand and lie.
Yeah, I'd agree with that. I mean, it's one thing that their story kind of fudges a little bit, but it's another one when they come out and say this is what they're going to do. And my client was being clever. He had read the case that said, he went to the law library and read the case and knew exactly what I had to do, and they did the same thing to a subsequent lawyer. And they did the same thing to another subsequent lawyer, but that lawyer did not get off the case.
So sometimes the client is being clever by half because they think, goes around the jail, this is how you can get your attorney kicked off the case, or just kind of throw a monkey wrench in the case in general. But I totally agree, we are not the 13th juror. It's not our job to try and determine if our client is telling the truth or not. We can certainly look at the file and say, well, here's the evidence they're going to use against you, and make them aware, your story doesn't match their story. I can't tell you what the jury's going to believe. But I don't think it's ever our job to tell the client, I think you're lying, so I can't put you on and let you testify.
Do you think you have to set a motion, or you can
If the
go
client,
talk to your supervisor and say, I need to get off this case, and just do it, move to withdraw? If the judge wants to press you as to why, that's another story.
Yeah, I've only seen it done as a motion, but ordinarily, when it's just a managerial decision, I don't know if, I've never been asked to do that before. I don't know if Colin has. So, I mean, we'd have to make that call if somebody came to us. I think more often what's gonna happen is like in Jeff's case, you have to do the motion.
Right. But I mean, if you can do it administratively, that would be preferable.
That might be a way around it unless you have a client like Jeff's who's just playing games.
Right.
And just trying to get it bounced around from attorney to attorney. And then the question is, can another attorney in the firm represent, or is that an imputed conflict for the whole firm? My preference would be to get a judicial ruling on it rather than, we have to decide if the whole firm's imputed or not.
I guess a quick question, is this happen when you were in trial, or this is like months before?
No, it happened before trial. I mean, he had read the case and he knew, and he basically, because the case was headed for trial. He didn't like the plea bargain he was gonna get, and he didn't want to go to trial, and that wasn't a good option either, so. Basically, say this, get me thrown off the case, and he could try again, or he could keep, win through attrition.
So,
Matt, is there any authority on when you should be making that motion? Because I've had the situation like Jeff's had before, and as we got closer to trial, he realized, oh, well, I actually want you to stay on the case, and then he went back to his original story, we didn't have an issue. Do you have to do it right away, or is it one of those things, again, you can advise your client, have the conversation and say, hey.
I guess it would depend on when they're gonna testify, how far away that date is.
Okay.
Right? So maybe you have some time to work on the client. I don't know, generally they say when a client, when a conflict arises, to try and resolve it as soon as possible. But, Michelle?
So can it go to another attorney in the office, if that were the case?
I would want a judicial ruling on that. But I think it depends, you know, if, as long as there's effective screening. I mean, if Jeff, you know, like he does, goes around the office and blasts to everybody. The whole office is gonna be conflicted, right? But if you can find someone in the office who hasn't heard the story yet, maybe you could give it to another attorney. All right, another hypothetical. Your client calls your supervisor and asks that you be removed due to conflict of interest. When asked what the conflict is, the client says, my attorney won't do anything I tell him to do, hasn't been able to give me the deal I want. And when the supervisor tries to explain that's not what a conflict of interest is, the client says, what if I punch my attorney in the face? What's the conflict then? So, do you think that this is a conflict of interest?
I feel like that's when I hear you in your office saying, if you're threatening to commit a crime, I have to tell people.
That's true, there is an exception. I think somebody's gonna, but you know, maybe the client is just blowing off steam, or you know, maybe they're just a figure of speech.
Are you saying, is it a conflict if he's just threatened it or if he's actually done it?
Well, right now, the hypothetical is he's just made a threat. And I don't know, does the supervisor know this client or know if it's a serious threat or not?
I think the
Is
rules,
the client asking a hypothetical?
Yeah.
I think the rules, you have to know it's a crime fraud,
Well,
crime fraud exception.
It's not a conflict of interest, right? There's not a conflict of interest. The question is whether it's a threat that would put somebody in danger, so I don't think there's a conflict.
Right. How about this? A few minutes later, the attorney walks into the supervising attorney's office and says, I think I have a conflict on my case. My client won't listen to me, he always yells at me because I can't get this ridiculous deal. And every time I see him, I want to punch him. Is that a conflict?
It sounds like
Who
they have
said that?
conflict.
It sounds like every day.
Every phone call.
So
exception.
obviously, common situation comes up a lot, and you know, obviously we have to deal with difficult clients. And it's not necessarily a conflict of interest, unless it's gotten to the point where the attorney and the client are irreconcilable. I did see a private attorney once in court doing one of these motions for new counsel and just really throwing his client under the bus. Just saying how much he hated the client, how rude the client was. Something that I don't think is ethical for an attorney to do. But, you know, it could be a point where an attorney says, no, it's just to the point where it's a conflict, it's irreconcilable. So ideas, you know, you try and build good rapport with the client from the beginning. You know, you want to have good communication, regular updates. If the client can see that you're working on the case, you know, hopefully it won't get to the point where they, you know, want to punch you in the face or you want to punch them in the face. And if necessary, file a motion on behalf of new counsel. For the motion, indigent clients have the right to appointed counsel, but they don't have the right to choose which attorney represents them. They also don't have the right for hybrid counsel. And the judges do this all the time where they'll appoint us as standby, and it's an incredible headache and it puts us in the worst situation. And recently, the court even tried to have like co-counsel between pro se and someone from our office. And we had to explain to the judge why that wouldn't work. So removal from appointed counsel usually requires showing to the court of a conflict of interest, an irreconcilable conflict, or a complete breakdown in communication. And the practice tips are, if you have to do any of these motions in your affidavit of support, should take no position on the motion. Remember, even if your client's trying to throw you under the bus, you still have a duty of loyalty. You can't do anything but try and hurt their case. You can't reveal any confidential communications unless the client makes a waiver or the judge makes a finding that there has been a waiver. And the client should definitely be advised of their Fifth Amendment rights. You know, they don't want to say anything that's going to hurt their case. Say just please should consider keeping your comments limited to why you want new counsel and not go over all the facts of your case because the prosecutor's going to be sitting there listening too. So dealing with threats of violence, if you ever do think you have a client making a threat of violence, please let caller or I know immediately, or your supervisor. If you think your client's just blowing off steam, that's fine, but it's still probably a good idea to talk to a supervisor about it. If you'd like, we'd be happy to go over talk to your client. Personal conflicts. And here are a few examples, because sometimes a personal conflict is imputed to the entire firm, and sometimes it's just disqualifies the individual attorney. So the first example is a client is charged with arson, the attorney is the owner of the building. So obviously the attorney is disqualified, but is the entire office disqualified? Probably not. I guess I have an example also where the victim of a burglary is employed at the public defender's office, and this has actually happened before, and in that case we did send it out just so there wouldn't be any appearance of a conflict, but not necessarily imputed, especially if you give it to an attorney who doesn't know anything about, you know, the allegations. But at some point, you know, if the person is a victim in the office, obviously, you know, you might have to interview them, and that could be awkward. And you might even have to impeach them at trial, you know, if you found out that they had something that you could use to impeach. And that could make for an awkward coworker situation too. We have had situations before where an attorney in the office was married to someone in law enforcement, and usually we can get around that just by how we assign the cases, and so that the attorney's not working on any cases that the law enforcement officer, and then that doesn't disqualify anybody else in the office from handling cases that that officer's involved with. But here's one I thought was kind of interesting. The client is a member of a white supremacy group that the attorney finds personally disgusting and odious. Is that a personal conflict?
Yes.
Gail?
Does it have to be? Because I feel like I could still represent that person.
Well, I think it kind of depends on the facts. But let's say that, let's say I'm Jewish, and this guy is accused of vandalizing the temple where I worship, and threatening and scaring people down at my temple, and walks into the office with a swastika on his hat and a lot of opinions about Holocaust denial. You know, I could go to my boss and say, you know, I don't think I'm the best attorney to handle this case. You know, but at the same time, obviously, none of our clients are, you know, definitely. We're not necessarily ever endorsing any criminal conduct or any misbehavior committed by one of our clients. So you can represent somebody without necessarily like saying like, I believe what my client believes. So.
What about like the Freeman School District and your kid went to that school and then you are now got the case to represent the shooter?
So that, I mean, that obviously happened in our office, and there were people in our office who had connections to Freeman, who knew people there or had associations with the school. So anyone who had one of those would probably be cordoned off and not involved in any way working on the case.
But we could keep it in our office.
Sure. Yeah, we did.
Okay. Okay.
Okay.
That's up on appeal right now. No, I'm just kidding.
So again, you may have all types of familial relationships, and that happens a lot. You'll say like, well, my client's wife is the victim on this case, and his cousin is on this case, and do we have to disqualify our office if, you know, a bunch of family members are represented on a bunch of different cases in our office? And it really depends, are they co-defendants, are they adverse to each other? They're not necessarily imputed to the entire firm unless there's actually that actual conflict. 3.7 talks about lawyers as witnesses. Doesn't come up a lot, but with few exceptions, lawyers are not to act as an advocate in a trial in which the lawyer is likely to be called as a witness. What happened a few times, and I get a couple times to me, was a bail jump charge against a client, and the prosecutor gave me a subpoena wanting me to come testify. So in both cases, we got motions to quash, and the court granted the motion to quash. It really does require that the prosecutor can't get this information from anywhere else. It's not feasible. And obviously in a case like that, they could get, you know, testimony from a clerk or whoever. Another practice tip, don't make yourself a witness. Don't commit yourself off a case, and I'm guilty of this myself. When I started, I went out to a crime scene, took a bunch of photographs for a case I was working on, and I went back to the senior attorney I was working with, and he says, how are you gonna get those in? So we had to go, I had to get the investigator and go back out. And obviously it just needs somebody who can look at the photo and say that's a fair, accurate depiction for foundation. But you know, maybe that's the client, but maybe you don't want your client to testify for other reasons. 3.8 is special responsibilities of the prosecutor. Again, prosecutor shouldn't subpoena you just to harass you, and especially not if the information is privileged, and only if it's essential to successful completion and not feasible to obtain from any other source. So here's a hypothetical. Your client asks you to file a civil lawsuit against one of the police officers who arrested him. Can you do that? It's outside the scope of what we're appointed on. So even if it wasn't a conflict, we wouldn't do it just because we haven't been appointed to do that. But let's say your client wants to hire you to do some private work. Says he'll pay you $500 to do a will, and you know how to do those, and you're willing to do it, and it will only take you about maybe an hour on your lunch hour. Can you do it? Well, as much as it would be nice if we could do side hustles and earn a little extra money, the county doesn't like it. Employees shall not directly engage in outside employment, and you're not supposed to do it during work hours. You're not supposed to use county telephones, computer supplies, or other resources. Or their rule is not even do it if it might be perceived by members of the public as a conflict of interest. So whatever that standard means. But here's a hypothetical. Let's say your cousin gets a DUI. It's an area of the law that you have much expertise, but your cousin doesn't qualify for a public defender but begs for your help, saying he can't afford a private attorney. Can you represent him pro bono? Well,
Maybe.
I think we've done it a few times, but
I think so.
these are rare exceptions, and you got to run it by Colin first. So first you got to get approval of the director. It must not create conflict with any other public defender clients. If conflict arises, that's the one, the outside case is the one that has to withdraw. All work must be done in your own time. You should clearly mark in TimeSoft, whenever you're going to court. Can't use county resources, which means you shouldn't even be doing it on your computer at work. And you're not covered by malpractice insurance, so something to consider. Any questions about that? Here's an ethical question. Let's say a client offers to give you his car in appreciation for all the hard work you've been doing. Can you accept? What if he just offers you to sell it to you at a great price?
It's not stolen.
So there's actually a state law on this. So you're not allowed to take anything of economic value, a gift, gratuity, or favor from a person if it can be reasonably expected that a gift would influence your action or reward for inaction.
What if, when you're doing reception, all these gifts keep coming in for an attorney from a client? Like flowers, and you're the cookies, and,
So I don't know, if a nominal gift is really not the problem, if it's just like a fruit basket or something like that. The problem is if it's, if it's a car or something of significant value. So that's where you're gonna get in trouble. The county policy mirrors the state statute. You also don't want to necessarily get into real estate deals with your clients. So there are exceptions under the RPCs if it's a fair deal, if everything's fully disclosed, if there's written consent, if there's an advice to seek opinion from a lawyer, but that seems like a lot of work to go through just to buy a used car. So it'd be like easier ways to do it without going through a client, even if you thought it was a super cool car and you made sure the title was clear. Okay, let's say.
I almost would never believe that.
Let's say your client is arrested in court and starts handing you his keys, his wallet, his watch, and asks you to hang on to them. What should you do?
I actually had this come up real recently, and I declined.
Yeah.
And I felt kind of bad because he had like a few $1,000s in cash on him. And, but I'm like, there's no way I can take it. I'll make a call for you to get him off your property. And the sad thing about that case is the jail took a big chunk of his money for child support. But I was no.
So here's some options. Pawn the watch, keep the cash, buy yourself something nice. Have the valuables locked in a secure location in your office. Or as Jeff said, just say no. And I think the best answer is just say, sorry, I can't. There are RPCs that make you liable if the property is damaged or misplaced. It also creates an ethical dilemma if any of that property turns out to be contraband, if there's drugs or something. And it's going to be a professional misconduct if, like, let's say the client accuses you of theft because he doesn't get all his property back or thinks he didn't get all the property back. So best policy is to say no. Is it permissible under the RPCs to have intimate or sexual relations with clients?
Yes.
Yeah.
It was before they were your client.
With client.
Well, let's ask Teresa Olson. She was a public defender over in King County. She got caught in a jail visiting room having sexual relations with a client on a murder case. And she was suspended and later resigned from the bar. But Rule 1.8 says lawyers shall not have sexual relations with the current client unless the consensual relation occurred, predated the existence of the client-attorney relationship. So Teresa Olson is now working in fashion.
She does look a lot better.
Yeah. So the comment says sexual relations that predate your client-lawyer relationship are not prohibited. So let's go through this hypothetical. Alan is appointed to represent Barbara on a DV. The alleged husband is Barbara's husband. Alan and Barbara dated before she was married. Their prior relationship was sexual and predated any attorney-client relationship. Now as her attorney, Alan meets with Barbara often to talk about her case. He's always professional. However, Barbara becomes increasingly flirtatious and confides to Alan how miserable she is in her marriage. She expresses regret for ending her relationship with Alan. She invites Alan over for dinner and wine. Afterwards, Barbara leads him to the bedroom, where they have sex. Has Alan violated the rules of professional conduct?
Yes.
Who says it's not a violation?
I think it's a super gray area.
Yeah. So I see it's a trap. So the comments for this particular rule are very intense. It says the relationship is almost always unequal. It's always problematic for an attorney to have any type of intimate relationship with a client. And it's difficult because we want to have good rapport, obviously, and maybe the client, right, within the professional limits. So, but, maybe you talk to a client about personal things about their family, and you start even becoming friendly. Some attorneys I know would send birthday cards to clients who are in custody, or, do personal favors for clients. But there has to be a line somewhere, and the difference, or the danger is that even if it's a consensual relationship, because of the power imbalance, you always have the client who is in need of the attorney's services. And maybe they're worried about going to jail, and maybe they don't want to displease the attorney in any way. So this can come up later, in a bar complaint, or you can find yourself getting conflicted off a case in a very embarrassing way. So what about, is it a conflict of interest for a public defender and a prosecutor today?
They do. Yeah, so dating, no, but being on the same case after that, yes.
That would be the problem. So here's a couple of attorneys from Marysville. Al Tracy was a prosecutor, and Marnie Whitney worked for a private firm that did public defense work. Because it was a small court, there were only 2 prosecutors in that courtroom, so they ended up appearing in almost 300 cases against each other. So they both lost their jobs, they're both reprimanded. Marnie works as a solo practitioner in Las Vegas now, and I think Al works in a small law firm over in Everett.
For months, they tried cases here at the Marysville courthouse while hiding a secret romantic relationship. Former city prosecutor Al Tracy and former public defender Marnie Whitney were often on opposite sides of the same case, creating an obvious conflict of interest that was never divulged to co-workers or clients. After an internal investigation, city administrators recommended Tracy be fired, but in June he resigned before that could happen, after 12 years with the prosecutor's office. Whitney was working as a public defender through the law firm of Feldman and Lee, a spokesman for that firm telling King 5, as soon as we learned of the inappropriate relationship between our employee and the Marysville City prosecutor, we immediately terminated her employment and also reported her actions to the Washington State Bar Association.
The couple worked on more than 300 misdemeanor cases here in Marysville. All of those cases are now being reviewed to see if any of them should be overturned.
A spokesperson for the city of Marysville telling King 5, we understand that out of all those cases, 3 now have new court-appointed attorneys, but there has not been any further court action on those cases. An attorney representing Ms. Whitney says there is no evidence that her clients were harmed in any way. In fact, he says, as a result of Ms. Whitney's efforts in negotiating outcomes for her clients with Mr. Tracy, her clients actually did much better than they might have if they were represented by other lawyers. Her attempts to reach Mr. Tracy were not successful today. In Marysville, Eric Wilkinson, King 5
So they
News.
taped it for about a year, if they had 300? Isn't that what you guys
Okay, so the funniest part of that is the attorney for the disciplinary matter who says his client got better results for her clients, you know, because of this relationship. So I've always thought that you can get better deals from prosecutors if you have good friendly relationships, but again, it has to be within professional standards. So as Kale mentioned, they could have immediately disclosed their relationship to their employers. They could have been assigned in courtrooms that they didn't have cases opposite each other. That was the problem. But this is something that cost them both their jobs and a scandal that will probably haunt them for the rest of their careers. So obviously something you don't want to get involved with. So clients often ask for favors, and the question always comes up, at what point does doing a favor for a client become an ethical violation? You get clients who will ask you, for example, of taking their stuff in court, but also clients will say, can you go feed my pet? You know, my poor cat's gonna starve to death if nobody feeds it. Or they'll ask you to go to their house to pick up some court clothes. Some attorneys are more willing to do favors than others, you know, but you have a huge caseload, so obviously you don't have time to go doing a lot of favors for clients. But at what point does it become unethical to do a favor for a client? So let's say that your client calls you and says he has a warrant. You confirm the warrant and explain to your client their legal options. The client asks you to file a bench warrant, which you do, a warrant recall. And then the client says he can't go back to his apartment because the police have been snooping around. Ask if you can give him a ride to a friend's house. It's freezing outside and he has nowhere to go. What should you do?
Call an Uber.
Call an Uber. You know, even calling an Uber for somebody who has an active warrant that the police are looking for could be a problem.
Yeah, that is a problem.
So, some of you probably recognize the fact pattern. Involves Mariah Wright, who was a prosecutor here in Spokane, who developed a relationship with one of her clients, a guy named Matthew Baumrocker. And what she ended up getting 2-year suspension for was he had called her and asked for a ride. She knew he had a warrant. She gave him a ride. And that's all that she was actually found to be in violation of, at least what she stipulated to do. So she ended up getting convicted of rendering criminal assistance. The charges were filed by the Attorney General's office because she knew when she gave him transportation that it was a means of avoiding apprehension. So if he had called and said, you know, what should I do? And she said, turn yourself in, or if she had picked him up and driven him straight to the jail to turn himself in, she probably wouldn't have been in trouble. But what she did was help him avoid capture. And it became quite a scandal, and this was all over the internet. It was viral. Part of it was because Mr. Baumrocker had tattoos, including one on his head that said criminal. And the other thing that made it kind of salacious for the news was that Mariah was a bodybuilder. And a picture of her in her bikini somehow found its way into Mr. Baumrocker's jail cell. They never actually proved how it got there, and it was on social media, so anybody could have done it. But the problem for Mariah was that she had visited Mr. Baumrocker in jail several times and used the jail visiting booth, the attorney's booth, when she had no reason to do that. So obviously something that you don't want to have following around for the rest of your career.
Who helped a wanted criminal escape a police dragnet, pleaded guilty today in Spokane Superior Court. Mariah Wright was convicted of rendering criminal assistance to Michael Baumrocker, a man Wright also would go in jail to see as she tried to get his illegal life back on track. That's where KXOI4's Jeff Humphrey joins us now live. And Jeff, this case got its start when corrections deputies thought that those visits behind bars were suspicious.
Benny, especially because Miss Wright was a deputy prosecutor, someone who was getting paid to send crooks to prison, not counsel them. We now know that Wright's relationship with Baumrocker was born out of her faith and compassion, but it's something that cost her her job and nearly landed Miss Wright inside the county jail.
I'm mortified to be here in front of Your Honor. I wish that I had made a different choice that day. I shouldn't have given him a ride.
It's been a half year now since Mariah Wright helped a wanted criminal give police the slip at this Hamilton Street convenience store.
I have a huge heart for people and animals that have nobody. I guess I'm a magnet for outcasts.
That compassion for outcasts is why Wright invited Matthew Baumrocker, a guy she once prosecuted, to attend her church. Wright was trying to get Baumrocker to give up his criminal lifestyle.
knowing what I know now, I would have made different choices. But again, I don't believe that anyone is without worth. I don't believe that anyone is without value, including Mr. Baumrocker.
Despite exposing herself to criminal charges, Baumrocker never took advantage of Wright's kindness, a waste of compassion summed up best by Wright's next-door neighbor, Ken.
Unfortunately, she tried to help somebody who did not deserve help, in my opinion.
Mr. Whitten, one of 8 people, including current prosecutors, who spoke on Wright's behalf today. While police think Wright betrayed them, Wright really, most of all, betrayed herself.
The court will not see me back here in this position again. I do hope that my bar license will survive the complaints that have been made, and I hope that I can continue practicing law someday.
Nadine, despite all the admirable things said by and about Ms. Wright today a judge still set her on 1-year probation and ordered both fines and community service. The real punishment here, though, the loss of her job and the stress of this incident is put on her friends and family. Reporting live in the Spokane County Jail, Jeff Humphrey, KXLI4.
So some of the things we didn't really talk about that are in the Inlander article about this was about there was a lot more to this relationship than just a good Samaritan trying to help somebody, and this was one of the love letters that she had sent, and the visits in the jails. You know, it really had no purpose to say that it was just being a good Samaritan, because I mean, she wasn't doing this for other clients. I mean, she was just doing this for this one guy. So it really made it suspicious, and part of her stipulation, you know, in this 2-year suspension was that she will never practice as a prosecutor again. So when last I heard, she was working up in Alaska doing criminal defense. I haven't heard from Mr. Baumrocker lately. I assume he's in custody somewhere. But obviously, you know, it's very easy to feel sympathetic to your clients because, you know, that's the kind of people public defenders are. We're very tender-hearted. And you might have a client who is very endearing, and you know, you feel sorry for them. And maybe you're going through a difficult patch too, you know, a relationship that just ended, and all of a sudden you've got someone who's, you know, listening to you and, you know, you can confide in. So it's easy to see how somebody could fall into this trap, but this is something that could really, you know, ruin your career. So you need to avoid it at all costs. How often do you think public defenders get disciplined by the bar? How many people read the back of the bar journal to see who got disciplined this month? Yeah, you don't see a lot of public defenders in there. I researched it, and I can only find a few in addition to the ones you've already seen. Longacre was a criminal defense attorney who was a former public defender, got suspended 60 days for failing to advise a client on a plea offer and sentencing implication. That's a really critical one. You got to make sure you document your files whenever you convey an offer, because a lot of times we do get public records requests where the person who's in custody serving a lengthy sentence is trying to get proof that their attorney never conveyed an offer. So if you have a letter that you sent the client, or a note or something, or even just a note in your file in your handwriting that you conveyed the offer, that's probably going to protect you from something like this. Brad Plum was a guy who worked for the City Public Defender's Office here in Spokane. He and his wife had been struggling financially during law school and had been getting welfare benefits. When he got hired by the City Public Defender's Office, he did not report it to DSHS. They found out about it, and then he was suspended for 3 years, later disbarred for similar conduct. Romero was a criminal defense attorney who accepted court appointments for indigent clients, disbarred for multiple violations. He was doing a thing where he was trying to squeeze clients for money. Say like, well, you know, we can only get this much for a 1077 expert, but the expert I want, you know, is a lot more. So he was always trying to get more and more money from his clients. That's what got him disbarred. Mitchell's was a part-time judge and former public defender who was suspended for 120 days for taking pleas from his own clients. And obviously that's problematic. But really, the thing that you should take comfort from as a public defender is we really don't get ethics violations or disciplinary action very often. So what should you do if you think you have a conflict of interest on a case? So run by Colin or I. An email from me is easiest. It's easiest if you can include both the client's name. Don't necessarily CC the other attorney involved, since we're trying not to perpetuate a conflict. and we don't know initially which client we're going to send out. But just provide a brief description, usually something along the lines of, my client is victim in X's case, just enough so that I can look it up and figure out, and then usually we'll try and figure out which client to send out based on who came in first and which client is a more serious case, et cetera, et cetera. What do you do if your supervising attorney doesn't think there's a conflict and you're not sure you agree?
Isn't it ultimately on you? I mean, if it's you think that there's a conflict, then you're the one that needs to make the decision. It's your bar number.
It's true. So when I was in college, I worked at the front desk at the dormitory, and we did summer conferences. One of the groups was an Orthodox Jewish group that came in, and I was standing in line behind 6 guys, waiting in the cafeteria for dinner. They're each asking the cafeteria workers what's in the meal, because they have to have kosher diets, right? So the first guy asked a bunch of questions, and then he makes a selection, moves on. The next guy asked exactly the same questions. And I'm sitting there like, didn't you hear that other guy just ask those questions? Each guy had to ask the exact same questions because each one had an individual responsibility for making sure they were in compliance with their religious beliefs and being kosher. So I think there's a certain beauty to that. And exactly as Zach said, each attorney is going to be responsible for, it is their bar license. And I have clients or attorneys who come in all the time saying like, I think this is a conflict, it's my bar license, okay. You can take a little bit of comfort. You can get another opinion from the WSBA ethics hotline. You can do further research and share the results with the supervising attorney for reconsideration. You can also file a motion with the court and get a judicial ruling. I'm happy with that too. I'm not offended at all by an attorney who wants to get another opinion. Under RPCs 5.2, you do have some cover if you get opinion from a supervising attorney. Subordinate lawyer does not violate the rules of professional conduct if that lawyer acts in accordance with supervisor lawyer's reasonable resolution of an arguable question of professional duty. And again, in my research, I could not find any cases where any public defender had been ethically disciplined for a conflict question. So, and the comments on all 5.2 specifically say, if question arises whether the interest of 2 clients conflict under 1.7, the supervisor's reasonable resolution of that question should protect the subordinate professionally if the resolution is subsequently challenged. So it's very unlikely that you're ever going to get disciplined if you went to your supervisor and got advice and you followed that advice. So that pretty much is mostly what I wanted to talk to you about conflicts of interest, but I also wanted to talk also about other types of conflicts that we face in the workplace. And what are the strategies for dealing with clients, because that's where most of our stress and conflict come from. So what strategies do you use for handling clients who are disagreeable, impatient, or even abusive? Who wants to start? Caleb.
Set clear boundaries.
Clear boundaries.
If a client is not communicating with me in a way that is acceptable, if they're shouting at me, if I'm unable to really have a conversation with them, I let them know that I can't be talked to like that, and that I can come back later and we can discuss it when they're ready.
Other does that?
Oftentimes it's difficult for me to convey information to clients because, well, not often, but sometimes they're really irate and they don't want to hear what we have to say. I'll draft a letter so that way the information can get out to them and they're on notice of whatever it is, the information that needs to be conveyed.
So one thing, and this was something Terrence Mitchell used to work in our office to include me in on. Sometimes we have a client who just shows up at the front door and they're just redlining and just yelling their heads off. He went to the vending machine and got him a snack. The guy ate, and 5 minutes later he calmed down. And I've been using that technique ever since, and it usually works. And I think part of it is the part of the brain that is the flight or fight mode. Once you get like a certain crashing level of blood sugar, you just kind of go into this red zone where nothing makes sense, and then you get somebody to eat that can usually calm down. Obviously, if somebody's in custody, that's not going to be something you can do. But yeah, at the very minimum, if you offer someone a snack, then they look like a jerk because you continue to yell at them. Important to remember that usually you're not the problem. Clients are dealing with their own demons, whether it's mental health, substance abuse, or poverty. Don't take it personal; it's strictly business. And then protect yourself by documenting your file well. Include the dates of each contact, the dates of investigation, and dates offers made and discovery reviewed. That's usually what the clients will complain about after the case is over. They'll tell their appellate attorney or who's ever handling their personal restraint petition that their trial attorney never reviewed discovery with them, didn't convey offers. If you file documents, that pretty much covers you for those things. Now we're going to talk about conflicts with coworkers.
Hands went.
My hand was up first.
No, it wasn't.
Jeff.
I think there's different strategies for dealing with difficult clients. Sometimes they really think that we're part of the man, and we're not really on their side. So sometimes it'd probably be too long of an explanation, but sometimes using a little reverse psychology with them, sometimes doing things to demonstrate that you're going to fight for them, and sometimes you have to yell back at them. I know George Kaplan, our old mentor, he once got a bar complaint for telling a client to go fuck themselves, and the bar dismissed the complaint. But I'm not telling you guys I'm going to probably get killed with the conflicts to go tell clients to go fuck themselves. But I think there's different strategies. There's different strategies for dealing with clients that sometimes need to be utilized, and I can probably give examples, if you want to talk to me privately. But I do think that your technique of going and getting a snack and doing things to de-escalate is probably the best way to handle a lot of these situations. But sometimes they just need to know that, if I try to set, I'm going to leave, right? And I could do that, but there's lots of different techniques I might go to first.
The difficulty is we're always on a time crunch because we have a limited amount of time. We have so many cases we're dealing with, and there's always the temptation just to try and rush the client, especially if you can see the light at the end of the tunnel, but the client's not there yet. Your goal is just to try and get there as quickly as possible, and the client wants to tell you all this irrelevant material about why they hate the victim, why the victim was always mean to them, stuff that doesn't have anything to do with their case. It usually pays to go through that process, to be patient and listen to the client, let them talk as long as they can. When they start to repeat themselves, maybe you can try and refocus and redirect them. But the more patient you can be, the more it will pay off later.
Well, that's helpful to start out with that by listening. We show up wanting to explain to them what we have to say and what we think they need to know. If you just sit down and start listening, that can avoid.
But I also agree with Kale, you're not a punching bag. It's not your job to sit there and take abuse from your client. And, maybe the client is, maybe they're on the phone yelling at you, just say like, it sounds like this is not a good time to talk. Why don't you, call me back tomorrow, after you've had a chance to rest and kind of think about it, and we'll regroup. Okay.
So I have two techniques that I've employed to various degrees, and a lot of times I just flat out forget to do it and get frustrated. But one of them, my wife and I went through like a parenting class called Parenting with Love and Logic, and one of the things that you do is you use empathetic statements up front. You ask, you ask your kid, what they think should happen, how it could go better, things along those lines, and you sort of give them opportunities or options, but you do what Kale had suggested is you set boundaries, right? Like, hey, I'm really sorry to hear that that's happened. I'm sorry that we're having this breakdown in communication. What do you think we could do to do this better? And then you give an option. Would you prefer that I just come to you and write things down? Or do we want to have more, do we want my investigator to come here so we can talk about things? Do you want to do this or do you want to do that? So you set these boundaries. And that works, I've found particularly well with a lot of my DV clients, who control to them is a real big thing. Sometimes another technique that I'll use is when they think that we're not listening or we're not hearing them, is you sort of mirror their language. So if they are swearing at you, I wouldn't say swear back after that, although I've absolutely done that. Keegan Lynch used to tell a story about when we switched over clients from my misdemeanor caseload. He picked it up and we had an interview with a client, and it was heated. But that was the way to break through to that client. That client and I had worked together for quite a while, and that was sort of how you got through. But I mean, if they're swearing, you know, and you're comfortable swearing along with them, that's fine. If you can, you know, if you can sort of mirror that, a lot of times them hearing that same sort of language or verbiage that they use, if you're able to use it appropriately, really breaks through to them and can sort of calm situations down, and it makes them feel like they're being heard, and you can use that to get further in your efforts with the client.
Maybe not jump too quickly into telling them, these are the consequences if you get convicted. Because they'll say, are you threatening me? Or if you immediately start talking about plea bargains like, oh, right, this guy's a dump truck, he's a public pretender, he doesn't really.
Right.
And I think Jeremy talked about this in one of his series too, that, you know, if you're always, you know, goal is talking about like, this is, you know, how the trial's gonna go, here's how we can kind of defend against this, you know. Eventually the client's gonna bring up like, well, are there any other options? And you say, oh yeah, there's plea bargains if you want, you know, I can talk to the prosecutor, but here's the trial. You know, so they don't think that, you know, you're just there to sell them out and get rid of them as quickly as possible. Anything else on clients before we move on to coworkers? All right, let's talk about coworkers. All right, so various types of conflicts that we have, you know, within the office. Some are task-oriented, sometimes relationship, process, status, organizational conflicts. Whatever the source of conflict, you know, we have to deal with it as an office because it kind of affects everybody. So here's a hypothetical. Abby and Bill work in an office where they get similar assignments. They dislike each other. Abby thinks Bill is a brown noser who always tries to curry favor with the boss. Bill thinks Abby is a slacker who never steps up to help when needed and dumps her works on others. One early morning, the boss asked Bill about a project Abby was working on. Abby hasn't arrived yet, and the boss is worried that a deadline will be missed. Bill retrieves the documents from Abby's desk, completes the assignment, and advises the boss it's done. When Abby finds out, she's furious. She tells several co-workers that she was handling the project fine, there was no reason for Bill to invade her workspace. She tells other employees that Bill is trying to get her fired and that others should watch their backs too. How should this conflict be handled?
I like to leave my office as disorganized and disgusting as possible. Old coffee cups, food that's spoiled.
Tinfoil everywhere.
Tinfoil everywhere. That way, nobody's gonna go into my office to get files. So that's how I would.
I mean, shouldn't the boss be communicating with Abby about the task she's working on or the assignment rather than with Bill?
So the hypothetical is Abby's not there yet. She hasn't come in yet this morning. But the boss is worried about a deadline, and so Bill's trying to be, either Bill's trying to be helpful or he's trying to undermine Abby.
I still feel like the boss should have Abby's cell phone number.
Is the question is, how should this conflict be handled from whose perspective?
So there's a conflict between two coworkers. Bill and Abby are having a problem.
So at what level, should the coworkers resolve it or should the boss?
That's the question.
That boss should.
Yeah, the boss should probably step in there and have conversations.
Okay. So the county employee manual does have standards of conduct. All county employees are expected to represent the county in a professional manner that is courteous, efficient, and helpful, respecting the confidential nature of the records and information that we have access to. It also talks about expected types of behavior include being respectful and courteous to customers, workers, county leadership, being a team player, taking initiative, maintaining attendance, communicating effectively, conducting oneself in a professional manner, a positive manner, demonstrating honest and ethical. So, you know, in this situation, I guess the concern that jumps out to me is Abby's behavior going around complaining to coworkers. So is that appropriate, what she did?
I think everybody did something wrong.
Okay. Ben?
So a couple of things. One, there's obviously a little bit of an issue, and I hope it's not this way in our office, but I know to an extent that it is. Right, we are sort of service-based organization, right? We're supposed to be taking care of our clients. So in theory, we shouldn't have an issue, you know, if Melissa has to take care of something for my client, the only thing that would be a problem for me was that I put that on her to do that. That would be the problem, right? But I shouldn't get upset if my client's got an issue or there's a deadline or something along those lines and Melissa comes in and helps out and takes care of that because that's what needed to happen. So one, I would think that our office has a culture of everybody, you know, all for one, one for all, everybody pitches in. So that I don't think is necessarily an issue in our office, but let's say that it is, because I think everybody has some pride in their work. The next thing would be, yeah, we shouldn't be running around spreading gossip or whatever that is. You know, if there's an issue, we should be professional enough that we can address it with each other, right? And come in and say, hey, you know, this happened. Either you know, what can we do to help so that doesn't happen again, or how can I fix this? You know, I'm guilty of that, very guilty of that. Even just, I think this week, you know, I did something that I don't think was right, and then eventually went and talked to somebody about it because I didn't handle the situation well. And so, you know, that's how we should do it in this office, is we should be able to freely talk to each other. You're not always gonna get along with everybody, so maybe if that's the situation, then yeah, you go and contact a supervisor or something along those lines and handle it that way. But I know that in this office, we've had a lot of problems with people who've gone, not to other people, or not to their supervisors, but sort of go around and talk about things behind people's back. That just festers and leads to problems.
Not just our office, I mean, any office.
Oh, no, yeah, that happens everywhere, but
right,
for
it
sure.
just creates a toxic environment when people do that. So, again, you know, we're supposed to reflect positivity and use conflict resolutions that are approved by the county. So, first of all, you know, you shouldn't be discussing, you know, conflict with a coworker with other colleagues who are not involved. Go directly to the person, maybe calmly ask what occurred, find a quiet place to talk. Don't accuse, don't assume facts or any ill intent until you've investigated. Without assigning blame, explain to the other person how you perceived and attempt to work toward a resolution going forward. So if there's some reason that you can't do that, you know, or no resolution is reached, not feasible, then go talk to a supervisor and get advice. Or if that doesn't resolve the situation, then you can talk to deputy director, or go over to HR or the union rep. But you shouldn't be bothering other coworkers with a problem that doesn't involve them, just distracts them from their work and creates a toxic environment. It kind of turns the office into, you know, one of those Survivor reality shows where we're trying to build alliances. Thing about gossip that people don't always get is sometimes people think that it creates intimacies or confidences and friendships with people. But really, if you had the experience, somebody says something negative, gossip about somebody else to you, as soon as that person leaves the room, you think like, God, I wonder what they are saying about me. So it doesn't make the person, you know, better friendly or better trusted. Gossip is generally defined as casual talk about others that may not be true. The NLRA protects the rights of employees to talk about work-related topics, including wages and working conditions. But gossip is not protected, not if it's false information that's outside the scope of work. So why is it harmful? It hurts morale. It has a bullying element to it. It creates a kind of a pessimistic outlook. People don't want to work in an office where that's happening. So it increases turnover, loss of productivity, and causes an erosion of trust. So gossip is, you know, very, very harmful, very toxic, and should be avoided. And if somebody, you know, tries to gossip to you, you know, maybe you say, I don't want to be part of this.
Or just say, hey, have you talked to that person? You know, maybe steer them back to that person.
There is such a thing as good gossip. I mean, you know, sometimes people come in Monday morning and they talk about what they did their weekend or their kids are doing in school, or, you know. I think the test is whether or not, you know, the thing you're saying about a coworker who's not present is, you know, would you say the same thing if they were in the room with you? Because if you wouldn't say it in front of somebody, you shouldn't say it behind their back. Other ideas for reducing stress, conflict, just take care of yourself. It's the, you know, the airplane thing. So cookies aside, try and eat right, try and exercise and get enough sleep, because you can't really take care of anyone else unless you take care of yourself. So it's like the mask, the oxygen mask on the airplane, you got to put yours on first before you can help anybody else put on theirs. And then, you know, have a work-life balance, try to find things outside of work that you like to do, whether that's, you know, camping or yoga or Zen or, you know, just going out, whatever you like to do. Just make sure you spend time with your friends and family having fun. Don't forget, the county has employee assistance program. Free counseling, you know, for any type of problem, you know, it could be a substance or alcohol problem, or it could just be regular day-to-day stress. You know, maybe you've had some recent life event like the loss of a loved one or something like that. This is free counseling, and it's a great resource, you know, if you need it. It's confidential. So summary, review RPCs and avoid conflicts of interest. If you think there's a conflict in judgment, let you off the case, make a good record for appeal. Document your files, protect yourself from bar complaints. Take care of yourself health-wise and find stress relieving activities, and take advantage of the county's resources. Any questions or anything else anybody else want to talk about? I think we're good then. All right, everybody have a good Friday.
Make sure you sign in. Make sure you sign your name, people.